Today we will discuss section 185 of Companies Act 2013, a very important section and quite tricky for students to understand. They tend to get confused while interpreting the section. So yes, let's understand section 185 of Companies Act 2013. So what is section 185? Section 185 is loans to director. First we will understand the intention behind section 185. Yes, section 185 of Companies Act 2013. So now section 185 is what? Loans to director. Let's say there is a company ABC Limited. This company has a director, Mr. A. Mr. A is the director of ABC Limited, alright? So now this company wants to give loan to Mr. A. For this, you have to check section 185. Can Mr. A take loan from ABC Limited is what is given under section 185 of Companies Act. Now, if company wants to give loan to its director, it would give loan from the funds of the company, right? It would give loan from the funds of the company, and this funds of the company is ultimately whose? This funds of the company is ultimately the shareholders, right? So the intention behind section 185 is to protect the interest of the shareholders. Funds of the shareholder should not be misused by the company or by the director. This is the intention behind section 185. Understanding? So the ultimately funds of the company belongs to the shareholders, and protecting interest of the shareholders is the ultimate goal of the lawmakers, right? So this is why section 185 becomes very important. Now this section has 4 subsections. We will understand each subsection. First is subsection 1. Section 185 subsection 1. What does this say? This says no company shall directly or indirectly advance any loan, including any loan represented by a book debt, or give any guarantee or provide any security in connection with any loan taken by. So what does this say here? Cannot give loan, cannot give guarantee, cannot give security. Taken by whom? To any director of the company, or of a company which is its holding company, or any partner or relative of any such director, or any firm in which any such director or relative is a partner. Let us break this down. Section 185 subsection 1. It says a company cannot give loan to director. So I will take the company to be ABC Limited itself. This ABC Limited cannot give loan to Mr. A, who is its director. This ABC Limited cannot give loan to director of the holding company. Let's say ABC company has a holding company. Can this ABC Limited give loan to the director of its holding company? No, it cannot give. Now what is the intention behind this? This is because this Mr. A and Mr. X should not have internal arrangement. Now yes, company cannot give loan to its director. What if company can give loan to the director of a holding company? At that time, these two directors would have internal arrangement. In order to avoid misuse of funds, they have introduced this, telling that company cannot give loan to the director of its holding company also. Next, a company cannot give loan to the partner or relative of the director. Now here director is Mr. A in our example. Okay. A company cannot give loan to the firm in which director or the relative is the partner. Director or relative is partner. These are the 4 cases given under section 185 subsection 1. What is it? A company cannot give loan to its director. A company cannot give loan to the director of its holding company. Third, a company cannot give loan to a partner or a relative of the director. A company cannot give loan to the firm in which the director or relative is a partner. Understanding? This is all about section 185 subsection 1. Clear? Yes. Now we will understand what is subsection 2. 185 subsection 2. This says a company may advance any loan, including any loan represented by a book debt, or give any guarantee or provide any security in connection with any loan taken by any person in whom any of the director of the company is interested, subject to the following condition. Now what is this? A person in whom any director is interested. A company can give loan to the person in whom any of the director is interested. Now here person, as you know, is person only natural person? No. Person includes both natural person and artificial person. So a company can give loan to the person in whom director is interested. Company can give loan to person in whom director is interested. Clear? Subject to the following conditions. What are the conditions? The first condition is special resolution in general meeting. You can give loan to the person in whom the director is interested, but only after taking shareholders' approval. Clear? Now, as you all know, in general meeting, in the EGM, when you give EGM notice, along with EGM notice, what will go? Explanatory statement, right? We have to explain the reason behind the agendas. In the notice, only agenda will be there. The explanatory statement attached to that notice explains the intention behind the agenda. So, special resolution has to be passed, first thing. Second, the loan has to be utilized by the borrowing company for its principal business activities only. Second is utilization of loan only for its principal business activities. Clear? A company can give loan only when the special resolution is passed, plus utilization of loan has to be only for its principal business activities and for no other reason. This is again to protect that the funds are not misused. Alright, now we will see. Now we saw company can give loan to the person in whom director is interested. We will understand who is this interested person. So as you all know, person is not just natural person, it is also artificial person. So any person in whom any of the director of the company is interested means any private company of which any such director is a director or a member. Second, any body corporate at a general meeting of which not less than 25% of the total voting power may be exercised or controlled by such director. Or third, any body corporate, the board of directors, managing director or manager is accustomed to act in accordance with the directions or instructions of the board or director of that lending company. 3 cases. We will understand this. Now, we are done with section 185 subsection 1. Next is 185 subsection 2. We saw, now first we will understand who is the interested person. First, a private company where the director is the director or the member. Understanding? To whom the loan is being given. That director is either the director or member of a private company. Then this company becomes the interested person. Clear? Second, any body corporate where at least 25% of the total voting power is controlled by whom? Is with total voting power is with director. So the director to whom the company wants to give loan, at least 25% of the total voting power is with the director, either by himself or along with other directors. Third, any body corporate where the board or the manager or the managing director acts on direction of the director or board's instruction. So basically control is with whom? Control is with the director. So the body corporate where the manager or the managing director or that entire board is being controlled by this director to whom the company wants to give loan. Understanding? Simple, clear, 3 cases. First case, a private company where the director to whom the company wants to give loan. Here director means who? That person to whom the company wants to give loan. Now this person is either the director or the member of the private company. Clear? Now next is the body corporate. The director of that company holds at least 25% of the total voting power of that body corporate. Third, a body corporate. Controlling of that body corporate is with whom? Controlling is with the director. At that time you can tell that this person in whom director is interested. Clear? So can the company give loan to such person? Yes, provided 2 conditions are fulfilled. First is you have to pass special resolution. Second, the utilization of that loan is only for its principal business activities only and not for any other purpose. Clear what is section 185 subsection 1 and subsection 2? Simple? Yes. Now we will see section 185 subsection 3. This subsection gives exception to section 185 subsection 1. 185 subsection 1 says what? You cannot give loan to director. But to some directors you can give loan provided certain conditions are fulfilled. We will see what are the exceptions. What is it? Nothing contained in subsection 1 and 2 shall apply to the giving of any loan to a managing director or a whole-time director as a part of the condition or service extended by the company to all its employees or pursuant to any scheme approved by the members by special resolution. What is it? First we will only understand this part. Subsection 3, clause A. Section 185 subsection 3, clause A. What does it say? This says that a company can give loan to its managing director or whole-time director. This is only applicable to managing director or whole-time director who has completed their employment tenure. Okay, so there is a managing director or whole-time director who has completed their employment tenure. Their tenure was for 5 years and they have completed that tenure. Now to this director, to this whole-time director or managing director, company can give loan. Now what is the intention behind this? They can be retained, right? Now if at all once the employment tenure is completed, you would want to stay there only if you get certain benefits, either salary hike or whatever. In order to do for that particular reason, the company can give loan to director and attract them to retain them. Clear? So this is the first case. Or pursuant to any scheme any scheme that is approved by shareholders by special resolution. Got it? So shareholders have approved, they all together have decided that pursuant to this particular scheme, we can give loan to director, we can give loan to managing director or whole-time director. So pursuant to any scheme which is approved by shareholders, the company is giving loan, that is valid. Understanding what are the two exceptions under subsection 3 clause A. First is conditions, their employment tenure has been completed. At that time the company can give loan, or pursuant to any scheme approved by the shareholders in general meeting by special resolution. They have approved at that time, pursuant to that scheme, the company can give loan to the director. Clear? This is first. Second, a company which is in the ordinary course of its business provides loans or give guarantee or securities for the due repayment of any loan, and in respect of such loans and interest is charged at a rate not less than the rate of prevailing yield of 1 year, 3 years, 5 years or 10 years government security closest to the tenure of the loan. So there is a company, I'll give an example. There is a company, let's say HDFC. HDFC is a company, right? Yes, it is a company. Now there is a director of HDFC, let's say Mr. Y. This Mr. Y, can he take loan from HDFC, which is a bank? So banks, the ordinary course, through its ordinary course of business only, the ordinary course of business is what? Providing loans, giving money to people, right? Providing loans. So pursuant to its ordinary course of business, this company can give loan to the director, but no privileges will be given. Whatever interest rate is being given to others, same interest rate we will give you. We will not give you any other extra benefit just because you are the director. We will treat you the same way as any other person and we will give you loan. This is valid. So a company whose ordinary business itself is giving loan, that company can give loan to its director, provided no extra benefits is given. Clear? Third, any loan made by holding company to its wholly owned subsidiary company, or any guarantee given or security provided by the holding company in respect of any loan made to its holding company, wholly owned subsidiary company, or we have to read these 2 points together. Okay? Fourth point is any guarantee given or security provided by the holding company in respect of loan made by any company or financial institution to its subsidiary company. We'll understand this, don't worry. Next, provided that loan made under clause C and clause D are utilized by the subsidiary company for its principal business activities. We'll understand this. So there is a holding company. This company can give loan to its wholly owned subsidiary. A company can give loan to its wholly owned subsidiary. D. A company can give loan to its subsidiary. This is the difference what is given in clause C and clause D. Clause C says a company can give loan to its wholly owned subsidiary. Clause D says a company can give loan to any subsidiary, normal subsidiary. Provided, these two only provided if the utilization of the loan is for its principal business activities. So utilization for principal business activities only, not for any other purpose. Clear? Clear all of you? All the points clear? These are the exceptions under subsection 3. Understood? Section 185 subsection 1 says company cannot give loan to the following people, 4 people, right? Second, 4 things. Next, section 185 subsection 2 says that in person in whom director is interested in, company can give loan to them only after passing special resolution plus utilization only for its principal business activities. Third, Exception to subsection 1. Company can give loan to its whole-time director, managing director, provided their employment tenure is completed or pursuant to any scheme that is approved by special resolution in general meeting. A company can give loan to a director if that company's ordinary business itself is giving loan, provided no special benefits is given to the director. C. A company can give loan to its wholly owned subsidiary. D. A company can give loan to subsidiary, provided utilization is only for its principal business activities. Clear? Yes, this is all about subsection 3. So we are done with section 185. Now we will understand what is section 185 subsection 4, which is the penalty provision. If any loan is advanced or any guarantee or security is given or provided or utilized in contravention of the provision of this subsection of this section, if it is contravened, then what is the punishment? What is the penalty? Company shall be punishable with a fine which shall not be less than 5 lakh rupees, but which may extend to 25 lakh rupees. 5 lakh to 25 lakh on whom? On the company. Every officer of the company who is in default shall be punishable with the imprisonment. So that is why it is a very important section. He shall be punishable with imprisonment for a term which may extend to 6 months or with a fine which shall not be less than 5 lakh rupees, but which may extend to 25 lakh rupees. So imprisonment which may extend to 6 months. Who? Imprisonment on whom? Every officer of the company who is in default. You know, right? Officer of the company who is in default, there is a definition only who all will be included in that. So they will be having imprisonment up till 6 months or fine either from 5 lakh to 25 lakh, whatever is the range. And the director or other person to whom any loan is advanced or guarantee or security is given or provided in connection with any loan taken by him or any other or the other person shall be punishable with the imprisonment which shall extend to 6 months or with a fine which shall not be less than 5 lakh but which may extend to 25 lakh or both. So it's the same thing. This is for officer in default. This is for director or person who got loan. Basically, director who got loan. Director or person who borrowed money. So first penalty, first fine is for the company, which is 5 lakh to 25 lakh. Second is every officer in default. What is the penalty for them? Imprisonment up till 6 months or fine 5 lakh till 25 lakh. Third, the director or the person who has received the money, who has borrowed the money, who got the loan, who received the loan, for them it is the same thing. 6 months imprisonment or 5 lakh to 25 lakh or both. So this is all about section 185, loans to director. A very important section and quite easy, right? Yes. Thank you.